Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Indecent Exposure Lawyer, Chicago, Illinois. If you're facing indecent exposure charges in Chicago, Illinois, it's important to take the situation seriously and secure legal representation as soon as possible. A conviction for indecent exposure can carry serious criminal penalties, including potential felony charges, jail time, fines, mandatory sex offender registration in some cases, and long-term damage to your reputation and future opportunities. At Combs Waterkotte, our criminal defense attorneys understand how stressful and overwhelming a Cook County public indecency charge can be. Whether your case stems from a misunderstanding, mistaken identity, or false accusations, we'll work to build a strong defense strategy aimed at reducing or dismissing the charges against you. Call 312-500-HELP today to speak with an experienced indecent exposure lawyer serving Chicago and all of Cook County, Illinois. Indecent Exposure Lawyer in Chicago, Illinois, serving all of Cook County. An indecent exposure charge in Chicago, Illinois can affect nearly every aspect of your life. Beyond the possibility of fines and jail time, a conviction may damage your reputation, career opportunities, and personal relationships. In certain situations, prosecutors may even pursue penalties that include mandatory sex offender registration. That's why it's critical to have an experienced criminal defense lawyer on your side from the very beginning. At Combs Waterkotte, we understand that indecent exposure allegations can arise from misunderstandings, false accusations, or situations taken out of context. Our legal team takes the time to understand your side of the story before building a defense strategy tailored to your case. With decades of combined criminal defense experience, we know how to challenge weak evidence, question witness credibility, and negotiate aggressively with prosecutors throughout Cook County. When you hire our firm, we'll work tirelessly to pursue the best possible outcome for your case, whether that means getting your public indecency charges reduced, negotiating for dismissal, or fighting for you at trial. We know what's at stake, and we're committed to protecting your future every step of the way. If you're ready to fight back against indecent exposure charges in Chicago or anywhere in Cook County, call Combs Waterkotte today at 312-500-HELP or contact us online for a free, confidential consultation. What is public indecency in Chicago, Illinois? Under Illinois law, the offense that is commonly colloquially called indecent exposure exists under a law called public indecency. The statute, 720 ILCS 5/11-30, defines 4 components that must be true for indecent exposure to occur. The offense must be committed by a person 17 years of age or older. The offense must occur in a public place. The offender must commit an act of sexual penetration or sexual conduct. The offender must lewdly expose their body with the intent to arouse or satisfy their own sexual desire. The statute defines a public place very broadly as any place where the conduct may reasonably be expected to be viewed by others. In practice, this typically means public indecency occurs in locations in Chicago, like parked cars, apartment balconies, porches, beaches, alleys. And while sexual penetration and sexual conduct are specifically defined under Illinois law, lewd exposure is not defined, allowing for a decent amount of leeway for criminal defense attorneys to argue against the charges. The statute also specifically mentions that the act of a mother breastfeeding her infant child in public does not constitute public indecency. What are the penalties for indecent exposure in Chicago, Illinois? The base-level offense for public indecency in Chicago, Illinois, is a Class A misdemeanor. A Class A misdemeanor conviction can result in up to 1 year in jail and a fine up to $2,500, though there's typically a bit of wiggle room for first-time offenders with clean records. There are, however, instances where public indecency may be charged as a Class 4 felony, a conviction for which may result in 1 to 3 years in prison and a fine up to $25,000. These instances include a third or subsequent public indecency violation, committing public indecency within 500 feet of a school when children are present. Does a Chicago public indecency conviction require sex offender registration? Yes, a conviction for public indecency in Chicago can require registration on the Illinois Sex Offender Registry. The Illinois Sex Offender Registration Act, SORA, specifically mentions in 730 ILCS 150/2 B 1.11. A third, felony-level conviction for indecent exposure requires registration. The Act, however, does not necessarily require registration for all felony-level public indecency offenses. For instance, if a first-time offender commits indecent exposure within 500 feet of a school and is charged with a felony, they do not have to register as a sex offender. Sex offender registration requirements only trigger after a third public indecency conviction, a quirk in the Illinois compiled statutes that tends to be a bit confusing. Indecent exposure in Chicago. Frequently asked questions. Public indecency is the sex offense under Illinois law that tends to confuse Chicago and Cook County residents the most. Questions about public urination, fines, statutes of limitation, and what actually constitutes a public place tend to be confusing. The expert criminal defense attorneys at Combs Waterkotte are here to help. Our Chicago area attorneys have answered some of the most frequently asked Cook County indecent exposure questions below. What is considered public indecency in Chicago? Under Illinois law, public indecency generally involves engaging in sexual conduct in public or exposing your body in a lewd way with intent to arouse your own sexual desire. Prosecutors must usually prove the conduct occurred in a public place and was sexual in nature. In Chicago, arrests commonly involve alleged flashing, sexual activity in public, or public urination cases where police believe the exposure was intentional or offensive. Is indecent exposure a felony in Chicago? It can be. Most Illinois public indecency cases in the Chicago area are charged as Class A misdemeanors. However, the offense may become a Class 4 felony for a third or subsequent conviction, or if certain aggravating factors apply, like committing the offense near a school while children are present. Felony convictions can carry prison exposure and other long-term consequences. Is there a public indecency fine to pay for a conviction in Chicago? A first-time public indecency conviction in Illinois is usually a Class A misdemeanor punishable by up to 1 year in jail and fines up to $2,500, plus court costs and probation conditions. Repeat offenses or certain aggravating circumstances can increase the penalties and potentially lead to felony charges and a fine up to $25,000. Is there an indecent exposure statute of limitations in Chicago? In Illinois, misdemeanor public indecency charges are generally subject to an 18-month statute of limitations. Felony charges, though, usually have a longer limitations period. The exact deadline can vary depending on the level of the offense. Speaking with a criminal defense lawyer quickly is important if you believe charges may be filed. What happens if you get caught urinating in public in Chicago? You may receive a citation, ordinance violation, disorderly conduct charge, or public indecency charge, depending on the circumstances of the conduct. In Chicago, public urination arrests are common in nightlife areas and around bars or festivals. Prosecutors must generally prove sexual intent to convict someone of public indecency, which can become an important defense in many urination-related cases. Is public sex illegal in Chicago? Yes. Illinois law prohibits sexual conduct or sexual penetration in a public place. A conviction for public indecency can carry misdemeanor or felony penalties depending on the facts and any prior offenses on your record. Police in Chicago frequently make arrests involving sex in cars, in parks, on beaches, in alleys, and other places visible to the public. Is flashing illegal in Chicago? Yes. In Illinois, intentionally flashing your genitals or body in a lewd or sexual manner in public can lead to a public indecency charge. Prosecutors generally must prove the exposure was done to arouse or satisfy sexual desire. A prank, drunken behavior, or accidental exposure may raise important defenses depending on the circumstances. Can you be charged with indecent exposure in your own home in Chicago? Possibly. Illinois defines a public place broadly to include locations where conduct could reasonably be seen by others, which means exposure inside a home may still lead to charges if it was visible from outside, like through windows, balconies, or open doors. Whether prosecutors can prove the conduct was truly public depends heavily on the facts. Criminal defense strategies against Chicago public indecency charges. Indecent exposure is not a charge you want to take lightly in the Chicago area. At Combs Waterkotte, we've helped clients fight public indecency charges in Chicago before. We've found the following criminal defense strategies to be particularly helpful at securing acquittals, charge reductions, and even outright dismissals in these cases. Lack of sexual intent. One of the most common defenses to Chicago public indecency charges is lack of sexual intent. Illinois prosecutors typically must prove the exposure was lewd and intended to arouse or satisfy sexual desire. In many cases involving public urination, intoxication, wardrobe malfunctions, or reckless behavior, there may be no evidence of any sexual motivation. A defense lawyer can try to argue that the conduct was embarrassing or inappropriate, but not criminally indecent under Illinois law. Challenging whether the location is actually considered public. Illinois law broadly defines a public place, but prosecutors still must show the conduct could reasonably be viewed by others. Defense attorneys may challenge whether or not the alleged exposure actually occurred in a truly public setting. Cases involving parked cars, private residences, balconies, alleys, or secluded areas often depend on visibility and access by bystanders. If the public could not have realistically observed the conduct, the state may struggle to prove this essential element of the offense. Defending against public urination charges. Many public indecency arrests in Chicago involve allegations of public urination rather than sexual misconduct. In these cases, criminal defense attorneys often argue that the conduct lacked any sexual purpose and therefore does not meet Illinois's definition of lewd exposure. Lawyers may also negotiate for reduced charges, such as ordinance violations or disorderly conduct, to help clients avoid the stigma and long-term consequences associated with sex crime accusations. Fourth Amendment violations. Some Chicago area public indecency cases involve unlawful stops, detentions, or searches by CPD officers. Defense attorneys may file motions to suppress evidence obtained in violation of the Fourth Amendment. like if officers lacked reasonable suspicion to detain someone or unlawfully searched a vehicle without probable cause. Weakening the prosecution's evidence can significantly improve the chances of dismissal or reduced charges. Miranda rights and improper police questioning. After an arrest for public indecency in Chicago, police officers must respect a defendant's constitutional rights during questioning. If investigators failed to provide Miranda warnings before conducting an interrogation, a defense lawyer can seek to exclude incriminating statements from evidence. In Chicago public indecency cases, defendants sometimes make damaging admissions while intoxicated, embarrassed, or confused. Challenging those statements can become an important part of the defense strategy. Lack of reliable evidence. Cook County prosecutors must be able to prove every element of public indecency beyond a reasonable doubt. In many cases, though, there may be little physical evidence supporting the accusation. Surveillance footage of the incident may be unclear, witness accounts of what occurred may conflict, and officers may not have directly observed the conduct in question. Defense attorneys often focus on exposing gaps in the prosecution's evidence and emphasizing that suspicion alone is not enough to support a criminal conviction. Negotiating alternatives to a conviction. Even in cases where dismissal is unlikely, experienced Chicago defense attorneys may still be able to negotiate alternatives designed to protect a client's future. Depending on the circumstances, prosecutors might agree to reduce charges, mandate supervision, defer prosecution, require counseling, or decrease state-level charges to municipal ordinance violations instead of seeking a conviction. These resolutions can help clients minimize jail exposure, avoid felony consequences, and reduce the long-term impact of their alleged indecent exposure on employment, housing, and professional opportunities. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.